If you are using the South Carolina Residential State Contract, Form 310, here are a few tips on how the due diligence section works. The buyer has one date for all investigations. The due diligence expiration date must give the buyer and seller enough time for inspection, repair request negotiations, an amended contract, or termination. An amended contract or termination must be completely finalized prior to the due diligence expiration date, or the contract becomes as is. How much time should you give your buyer to perform due diligence? Ask yourself what needs to be investigated. 1. Does the buyer have complex questions that need to be answered about the property? For example, does the buyer plan on having livestock on the property, and will this be allowed? Or does the buyer want to operate a business from this location? The buyer will need enough time to investigate all questions they may have during this time. 2. What are the conditions of the home? Is the home an older villa in poor condition, or is the home only a year old and well maintained? Do you need extra inspections, such as a pool inspection or HVAC? 3. What about access to the property? Are there renters in the home? If so, will this delay the inspector from scheduling an appointment? 4. How much time will you need to schedule the inspection, receive the report, let your buyer review the report, and decide on what repairs they will ask for? How much time will the seller need to review your requests and respond? You will also need time to negotiate and enough time to gather signatures on all required documents. 5. How long will it take to have a fully executed contract? For example, you give a 10-day due diligence timeframe with the initial offer, but you do not have a fully executed contract for 3 days. Now you only have 7 days in your due diligence time. Tip: put an expiration date on the offer, for example 3 days, and add that 3 days to your due diligence time. Now you have to decide if you want to include a termination fee in the contract. A common question asked is, what should the amount of the termination fee be? Or, do I even need to include a termination fee? This will be a decision for your buyer to decide. A termination fee is not required, and the amount should be what your buyer is willing to pay to walk away from the contract. It is important to note, the termination fee is only owed if the buyer terminates for due diligence reasons. If the contract is terminated for any other contingency listed in the contract, example, appraisal, finance, or CL 100, the termination fee is not owed. To terminate the contract, you must provide Form 313, Notice of Termination, and the termination fee before the due diligence time is over. If earnest money has already been received, you should also include Form 518 so the money can be released. The termination fee is always paid to the seller. The fee and the termination forms must be delivered to the seller prior to the expiration of due diligence. If the seller does not receive both items, you did not successfully terminate the contract, and the contract will now become an as-is contract. Where the termination fee will be delivered should be noted on the contract. The buyer can send the fee to the seller electronically, but this should be agreed upon upfront, and the account number should be provided to the buyer well in advance of the expiration date. Tip: make sure the due diligence expiration date is not on a weekend or holiday if you or the buyer are delivering this to the listing agent's office. If your buyer needs more time added to the expiration date, you must obtain this in writing, and it must be signed by all parties. You can use the standard contract addendum, Form 390, to extend the due diligence time. The buyer can terminate the contract for any reason, and the seller is not required to make any repairs. The only way to amend the contract is to have a signed agreement. The acceptable forms, as noted on the contract, are SCR 310, SCR 525, SCR 390, or SCR 391. Please note, you must deliver all repair requests at the same time. Once you submit the repair request, you can no longer ask for more repairs. Disclaimer: the information provided in this video about the South Carolina Residential Real Estate Contract, Form 310, and how due diligence works is for educational and informational purposes only and is not intended as legal advice. The content of this video should not be construed as legal advice or legal opinion on any specific facts or circumstances. The South Carolina Residential Real Estate Contract, Form 310, is a legally binding contract, and its terms and conditions should be carefully reviewed and understood by all parties involved. The due diligence period outlined in the contract is a critical time for buyers to take timely and prudent steps to investigate the property, coordinate inspections and repair requests, and negotiate repairs with the seller. Buyers should consult with a licensed attorney who is familiar with this contract and the applicable laws and regulations in South Carolina to ensure that they understand their rights and obligations under the contract.